Welcome to Heather Sells NYC with your host, Heather M. Cooper. Each episode is focused on helping people navigate through the intricacies of buying and selling real estate in New York City to get the greatest value. You can find this show on all the major platforms, including YouTube, LinkedIn, Apple Podcasts, Spotify, and on our website, heathersellsnyc.com. Now here's the host of Heather Sells NYC, Heather M. Cooper.
Hello. Good morning, Keren. Thank you so much for coming on.
Thank you for having me.
Such a pleasure.
Good morning.
Thank you. So I wanted to introduce Keren Birnbaum, who is a founding partner of Birnbaum Lewis, where she concentrates her practice in the areas of estate planning, trust and estate administration, elder law, and special needs planning, or what our firm commonly calls estate planning for the sandwich generation. Yes. Thank you so much for being here. I really appreciate you taking the time.
My pleasure. Thank you for having me.
Yeah, I always love talking about estates and working with trust and estates attorney because it's such an important process with real estate. It really goes hand in hand.
Definitely very symbiotic. They go together. You can't really have an estate issue without real estate or vice versa. It always comes together.
Yeah, absolutely. So what I really wanted to, I've had many estates and some are quicker than others. Now, from a real estate professional's perspective, if somebody comes to me and they say, oh, I want to list my property, what would be the first thing that a real estate agent, like what sort of questions would they ask you as a trust and estates attorney to make sure that everything is going to go smoothly?
Yeah, I mean, well, if you're looking from the selling side, right? If somebody walks into a real estate broker's office and says, listen, I want to sell my property. I want to sell my mom's property, my sibling, whatever. I think my first question is always, well, how is the property owned? Who is the actual person selling the property? Is it an estate? Is it a trust? Is it an individual? Is it multiple individuals? And then from there, once we have that answer, then we can know which direction we're going in because there's so many variables in ownership, right? I know you're dealing right now with somebody who's selling on behalf of an estate, that you can have a regular estate, you can have a complicated estate, you can have a trust, you can have multiple tenants in common, you can have joint with rights of survivorship, there could be a life estate. There's so many different ownerships that we can have. So it really depends. So my first question is always, how is the property owned?
Right. That is a good question because then you know what way to go. And then question about beneficiaries. I mean, I have the estate that I'm working on. I think there's one beneficiary, I guess, that the apartment was left to. And how does it work? I think there were a lot of beneficiaries in this estate. So, what if you have like $1 million estate, 20 beneficiaries, and you have the property and it's left to one beneficiary?
Yeah, so it's really up to the executor. So the executor is the person in charge of, I call it stepping into the shoes of the deceased person. So somebody dies, well, now that person can't act for him or herself anymore. They're dead. So the executor is a person who is now bringing that person back to life. So when we have a will, the executor goes to the surrogate's court, has the will probated. It's obviously a more complicated process that I'm saying right now. But once the will is probated, the executor is the one who's going to sell the property or call the real estate broker, handle all the transactions, sign all the documents, be the one at the closing, take the check, put it into an estate account. They are now that deceased person. And then once that process is all settled, then they distribute the money to the beneficiary. So it could be one beneficiary, it could be thousands of beneficiaries. It doesn't really matter. The executor is our point person. It's like they are the dead owner when it comes to estates. So sometimes you have multiple executors, and that always throws a nice little monkey wrench in, right? Because it's always, one too many when you have more than one. When, you know, too many cooks in the kitchen, if people don't agree, how much are we selling the property for? You know, different things come up throughout the process, which I'm sure you know when it comes to selling any property. So it's easier when there's one executor, but really the amount of beneficiaries, it doesn't matter. It's the executor who's in charge of pulling the strings.
Right, right. So basically, have you seen an estate where there are 5? Is it possible to have five executors? Is there?
I mean, I guess so. Why not? But I would never, on the planning side, allow my client to name 5 executors. That's insane. And then on the probate side, if I am presented with a will that doesn't make sense, you know, let's say there's 3 executors and they don't get along, or they do get along, but only one is in New York and one is more involved. Inevitably, that's what it is, right? Then the other 2 don't have to accept the position of being an executor. They can sign a renunciation. They say, you know, I'm refusing to be the executor. But I guess technically you can have 5 executors. I just don't know why anybody would do that. Typically, it's a situation where someone's like, I have 3 kids and I want to name all 3 of them because I don't want to hurt their feelings. And that's where I really sit back and I say to you, Heather, like, that's where we say we're social workers or we're therapists in this situation, because I don't want to deal with 3 executors on the flip side after they're gone, right? Who wants to deal with 3 personalities? 1 is enough. So right. On the planning side, I will sit with what's called the testator, the person writing the will, and say, listen, I know you want to name all 3, but let's actually walk through what that looks like and work through the process. Does it really make sense to name all 3? What are you actually worried about? Is it because you don't trust them? Is it because you're worried about their finances? Or is it because you just don't want to hurt their feelings? Well, then let's pick a manner in which we won't hurt their feelings. Maybe we go oldest to youngest in one document, the youngest to oldest in another document, or figure something else out. But 5 is crazy.
Right. I would think that 5 would be, you know, you would just not make any decisions.
Yeah, it would always be a stalemate. It would never work out. I mean, I guess it wouldn't, majority rules, but no, I wouldn't do it.
Right. And what in states, like, what's the longest time that you've, from when somebody unfortunately passed to an estate being settled?
Unfortunately, COVID really made things very slow in the surrogates courts. I am dealing with an estate right now. The longest one that I'm dealing with is over a year. I want to say in October it's going to be 2 years. So October is still 6 months away. I'm clearly not hopeful. I don't really know why that is. I think many of the court systems weren't e-filing access, meaning accessible, meaning I would have to go to the court, file my documents. I can meet with a clerk, talk to the clerk, all before COVID. COVID happened. The court still needed to continue accepting cases, especially with the amount of deaths there were initially. So they had to start this e-file system like overnight, and they didn't know how to do it. It was a very antiquated system going in person versus e-filing. And so what would happen is you'd e-file your documents, but then nobody would look at them on the court side for weeks because they were learning how to do it. And so now here we are 4 years later, and we're still like dealing with the backlog. And then you had a lot of overturn in staffing in the courts because people were retiring, people who had enough, they're not coming into court anymore. So there's a lot of turnover. Unfortunately, the system is very slow right now. So it's very hard when it comes to real estate, right? Because depending on the size of the estate, the real estate may be the biggest asset. And your hands are really tied because you have to have the will probated, you have to have the executor appointed. That's when you start with the sale of the property. And then once letters are issued, once the executor is officially appointed, the estate cannot be closed for 7 months from the date that letters are issued. So it's not like, even if I sold my property day 1 when my executor was appointed, I still have that 7-month waiting period till I can distribute the money to the beneficiaries. So it's a slow process. And that's why we're seeing more and more of trust creation or joint with rights of survivorship creation or life estate creation, because people don't want to deal with the surrogates court process right now.
Oh, I get it. So essentially, if somebody was appointed the executor today and we closed say May, the beneficiaries wouldn't be able to get the proceeds for 7 months?
That's correct. Yes. There's this period of time where the court rules say that the creditors of the estate have 7 months time to come forward from the date letters are issued, because that's when they're on notice. They have 7 months to say, hey, listen, so-and-so, the person who died, owed us money. So we're filing what's called a claim against the estate. And now the executor has to pay those bills first. The reason there's that waiting period is because after the waiting period, basically to the creditors, you snooze, you lose. You can't get it from the estate assets. You now have to go after the beneficiaries, and they're not going to pay. The beneficiaries, once they get the money, are not paying the debts of the decedent. So it's really to cover the executors' behinds, really to wait that 7-month period, because if they give the money out before that and then a creditor comes forward, the executor is on the line for that.
Very interesting. So just out of curiosity, so when somebody passes and they owe Uncle Sam money, they're not getting out of their debts. So
no, they're not getting out of their debts. Your debts don't die with you. They are still there. Now, if you don't have assets, right, you can't recover against something that doesn't exist. So I'm just speaking, there are exceptions to every rule. I'm speaking broad levels, right? We're broad stroking here, but yeah, no, your debts don't go away. Oftentimes what we'll see is a credit card bill, right, that hasn't been paid, or the expenses of the last illness actually are super expensive. So people don't realize an ambulance bill, right? How many estates have I gotten where there's an ambulance bill, a hospital bill? I mean, crazy things that we don't think, like, oh, of course there's going to be a bill for that. When's the last time somebody went to a hospital and didn't have to pay a bill, right? Those come in and they're expensive.
Right. Yeah. And then unfortunately somebody passes and then they realize that there's a $20,000 bill that has to be paid. So now it makes sense.
Or this other estate. I'm dealing with another estate right now, and the wife keeps getting creditor collection notices for like $200 on a credit card and $300 on this credit card. I'm like, relax, it's fine. There's nothing we can do, and there's nothing that can be done to them. It's not their fault. It's not the executor's fault until letters are issued. Once letters are issued, once we collect assets of the estate and there's money to pay the bills, then we'll pay the bills.
Got it. So the letters have to be issued. Is this when somebody even dies with a will?
It's only only when somebody dies with assets in their own name. So when they have a will, it's called a probate proceeding, and that's when letters testamentary are issued. When somebody doesn't have a will, New York State actually goes ahead and writes a will for them, and that's called an administration proceeding, and letters of administration would be issued there. And so we have an executor with a will and an administrator when there is no will. So in both instances is when that would apply.
Got it. Yeah, I remember when my dad passed away 10 years ago that he didn't have a will.
Yeah.
So it went through administration. But how do they know who to appoint?
There's a hierarchy in the law. There's a hierarchy. So it's going to be the spouse. If not the spouse, then the kid. If not the kid, then it goes up to the parents, to sibling. It's just this whole roundabouts circular way of getting to who the administrator is.
Yeah, because I think it was my sister and my brother, because they were the two oldest. Does that make sense?
Yeah, absolutely. It could have been one of them. It could have been any one of, I don't know how many there are of you. If there are 3 of you, it could have been any one of the 3. But or 4. But maybe, they were like, we'll take charge. That sounds good to have somebody else take care of it. For example, my family, I'm sure my brothers would just be like, hey, Keren, it's yours. We want out. You handle it because of what I do. But I could just say no, and they could do it. Depends on.
Have you seen instances where people say no?
Oh, yeah. Yes.
I'm like, why would they say no? Is it too stressful? Or they don't?
Different circumstances. So let's say I have a will and I name my spouse, but I haven't updated my will in 50 years and now we're 80 and my husband passed away and I don't want to be an 80-year-old executor. Like, let one of my kids take care of it. I don't need to do it anymore. They're handling all the affairs. Let them be the executor. So that's the reason why Another reason why is sometimes, I would say it's mostly when people don't update their wills. So maybe I don't have close family. I name a friend who's not really involved in my life anymore. They don't really want to act. They would decline. I'm dealing right now with an estate, actually with somebody from overseas, and the people that were named in the will are not U.S. citizens. So for an example like that, we can't, the court has rules about who can serve as an executor. So they can't serve alone. Yeah. So instead of, so they would be able to serve and appoint a U.S. person with them. So let's say they wanted to appoint me as their co-executor, they could. Not saying that's what they did. They didn't. They instead said no. And then the next in line was a U.S. person. So they stepped in. Every case is unique. There's no black and white when it comes to any of this. It's all like I always say to my partner, it's like a law school exam. Every file is like a law school exam on my desk. Nothing is easy.
Right. It sounds like real estate. Like no two deals are the same. No two clients are the same. But I guess that's the beauty of it, right?
Yeah. You get the personality in the mix, and then everything is just all over the place. Not to say it's not a bad thing, but
Yeah, exactly. And just, I guess, is there an advantage to creating a trust when somebody is younger rather than older, or just creating a trust?
There's so many different kinds of trusts that it's very hard to answer that question with saying yes or no, right?
It's a loaded question.
It is a loaded question. So I used to say for younger people, unless there was an estate tax concern, why would we create a trust? However, because the probate process is so slow right now, I am now recommending to many of my clients that they create trusts with the younger married couples with younger children. Why? Because I just told you how it's taking a long time for wills to be probated. Then once they are successfully appointed as an executor, we still have 7 months, right, till money can be distributed. Well, what happens if I have a young kid, right? Now I don't have access to the money to take care of this 5-year-old or whatever they need for however long it takes for the court process to be done and an executor to be appointed and 7 months to pass. I don't want to wait a year plus, a little less than a year. I don't want to not know. However, if I pool everything into a trust, and it could be a revocable trust, meaning I could change it whenever I want, and something happens to me, well, now whoever the trustee is going to have complete access to the money to take care of whatever they need for my child. It's automatically going to happen. So if I have a revocable trust, it just happens like that. Why wouldn't I want to be able to give my kids the complete access to it right now? So I am recommending for younger couples that they do a revocable trust. Now, as people get older, or depending on their assets, there are different reasons to do different things. So do I have property for business purposes? Do I have a Medicaid planning concern? Am I worried about how I'm going to pay for my long-term care expenses? Am I in my 70s and I need to get assets out of my name? Or do I have millions and millions of dollars and I'm worried about estate taxes? Do I have creditors? All of these things get put in the pot and shake it around to figure out which direction we go in. But whereas in the past, I would never recommend revocable trust for my younger couples, because why? It's just expensive now, right? Just do everything in a will. And it used to take a couple of weeks. So it takes 6 weeks. Okay, 6 weeks. But to take 6 months, a year and a half, it's too long to wait for money for little kids, in my opinion.
Right, because God forbid something, if something happens, we don't want to have the funds tied up.
Exactly.
If a partner or if a husband passes away.
Even if a partner or husband, or even if God forbid something happens to both of you, I say to my husband all the time, and this is only because I'm an estate planning attorney probably, but whenever we're in the car together, I'm like, if God forbid something happens to us, like who's going to knock on the door and tell the kids? How is that actually going to work? It's very real to be in the car with your partner, with your spouse, with the people that matter to you most. It's a scary thing to think about.
Yeah, it is. And probably a lot of people don't forward think about the future.
No, they don't. It's not something fun to think about, and it's not like a sexy conversation to have. You know what I'm saying? It's not like, let's sit around the table, a bunch of friends, and talk about, oh no, what's going to happen if we both die? Where's our money going to go? Where are kids going to go? We don't talk about that. That's not something we sit around the dinner table and discuss.
Right.
Unless you're friends with me, and then you have to.
I know. I would think that there's a lot of fear around a discussion around death and what is going to happen.
Yeah.
A lot of people.
Yeah, it's also, I mean, people say, oh, when you have kids, it's important. But I have to say, it's also extremely important when you don't have children, if you're just single, because presumably you have something that matters to you. You have assets that matter to you, or you have people that matter to you, or a foundation or a charity. Don't you want to make sure that what you have goes where you want it to go? All the more so, right? So if I have a will, I get to be the one driving the boat where it goes. If I don't have a will, well, New York State's going to decide. So maybe it's going to give everything to my parents. Maybe my parents don't want my money. Maybe they're doing estate planning and worried about Medicaid. They don't want my money. Maybe it's going to go to my siblings. Well, that's nice, but maybe I didn't want my money to go to my siblings. Maybe I wanted to go to some nieces and nephews or some relative that's not my sibling. So to have a will when you're an individual, I think I wouldn't say it's more important, but I would say it's equally important to when you have children. You want to make sure that, and I think that's a big misnomer out there, people don't realize. You want to make sure your assets go where you want them to go. Why are you working so hard if you don't direct where you want them to go? Right?
Yeah, that is really true. And a lot of people don't think about the future.
Yeah.
And they don't think about what's gonna happen with their assets. And what just came to me is that, God forbid somebody, what happens to someone if they get ill and they don't have power of attorney or
yeah, we didn't even touch on those. The power of attorney, the healthcare proxy is so
healthcare proxy. Yeah. What if I go to the hospital and God forbid?
I have to tell you, I have a client who actually had a healthcare proxy, was taken to the hospital. I won't give the details of how he landed there, but he was found somewhere on the street and taken to the hospital, and they intubated him. They called his sisters. His sister said intubate him. He was an individual, a single man, but his sisters he hadn't talked to his sisters in years. And they were not his agents under the healthcare proxy, but the paramedics who picked him up didn't know who he was, anything about him. I'm not even sure how the hospital got to calling the sisters. Long story short is when the friend who's the named agents found out, he went to the hospital and was like, what happened here? This guy had a DNR, essentially. He did not want to be intubated. He did not want to be resuscitated. And it actually became this whole process because the sisters showed up at the hospital trying to talk to him, and he ended up coming out of the situation, and made it very well known from there on to any, he used to then carry a healthcare proxy on him to say that he's appointing his friend and not his sisters. But there was, it's really important that especially if you have something specific in mind for what you want or don't want, that you make it known, because nobody's going to be inside your head if something happens to you.
It's true. I mean, God forbid, like in this instance,
that's a crazy, that story is particularly crazy. But yeah, I can't really give you the full details of it. It's just too crazy for this platform, but it just puts the nail on the head, right? Like, you need to make sure your wishes are known. If you do not want to be intubated, you better make sure that that's on you somewhere at some points, so that if you're found somewhere, if you're in a car accident, who knows with this world, what's going to happen, where we're going to be, at what time, that something can happen. You want to make sure that whatever you want to happen actually happens. And you can only do that by being proactive, not by being reactive.
Right. That's totally true. Yeah. If we want our wishes to be known, then we have to actually speak about it.
Yeah.
And speak about it to our most important people in our life.
Yes. And just bringing it back to the real estate for a second, I had a client who was in the middle of selling a property in Queens and buying a property in Chicago and had a stroke and had no advance directives, no power of attorney, no healthcare proxy. And so he's in the middle of 2 real estate transactions. And now all of a sudden,
wow.
he can't do anything. Our hands are tied. So as a real estate broker in that situation, that's an awful place to be, because now you have a seller who's like, wait a second, when is the closing? We can't have the closing yet. And you have the person who's expecting to buy a property and be in a property by a certain date that can't get there because the power of attorney, it doesn't exist. We now need to do a guardianship proceeding in the Supreme Court to have a guardian appointed. And then here we are waiting at the court's hands again, 6 weeks, 8 weeks, 12 weeks, pause everything, time out until those things, a guardian can get appointed, and then the purchase and sale can happen. So from a real estate perspective, maybe that's a question you guys want to ask too, right? So it's not only how is a property owned, but do you guys have your advance directives in place? God forbid something happens to you in the middle of this transaction.
That's a really good idea. So how did they know? Was he in a capacity to say who he wanted to appoint as a guardian? Like, how did they know?
He ended up passing away. He was married and he had kids, so it was obvious that the spouse would be the guardian. But there are cases where it's not so black and white. So let's say, like you mentioned, for you have 3 siblings. If something happened and, maybe I won't use you as an example, but what happens if the siblings don't agree, right? 3 against 1 or 1 against, whatever it is, 2 against 2, the judge is the one making the decision. So I used to also, there's what's called a community guardian. If there's nobody, so for example, the person that was intubated in the hospital that I was using as an example before, if he hadn't had advance directives, what happens in that case is that the hospital is now going to apply for a guardianship for this man or this woman. And the court doesn't know who the family members are, so they appoint what's called a community guardian. That's not a person. It's like an entity that's now in charge of taking care of the finances of this person. It's like a cold procedure versus just saying, hey, listen, I want to name Heather as my agent under my power of attorney, right? Why wouldn't I want to take care of that proactively rather than, God forbid, losing my capacity, being stuck and not having the ability to name who I want to name?
So interesting. There's so many different variables that come into play.
Yeah.
So, what if a person is, incapacitated and then they appoint a community guardian? Like, what if they need surgery? Then we don't want to wait. And they don't.
Guardian. Well, for healthcare, there is a hierarchy under the law. So if you're married, there's a spouse. There's a law in place. But if you're nobody, and I don't mean nobody's nobody. But if you don't have people, their decisions will be made for you. It's just the way it's going to be. And so they may be decisions that you don't want made for you. Right? Maybe I don't want to be intubated, but I'll have been intubated, whether I liked it or not. Here I am.
Right, because you don't have that healthcare proxy with you.
Not known, exactly.
Who would think of that? Now I'm thinking about that.
Yeah.
Now that we're talking about it, and now I'm going to think about, okay, who is going to make these decisions on behalf of me? We never want to have these conversations.
No, we don't.
Because everyone's always like, oh my God, it's morbid. But it's just, I guess, necessary. Let's just say.
Yeah. Have the conversation, have the family conversation, and then you're done. Open the book and then close it.
And it's necessary also in property ownership.
Absolutely. Right. Just like I said, for this one example, they didn't have an agent under the power of attorney. That's awful. What a bad situation to find yourself in.
Sorry. What about in that situation where the unfortunate, where the guy passed away? What if he didn't have a wife? And then the property was in contract. I wonder, and maybe this is more of a real estate question, if the buyer can walk away.
I think it depends on the contract, but in the event, somebody would have been appointed as the guardian. So it would have been a community guardian in the worst case scenario. So he had a wife and 3 kids. So there was always somebody who was going to be willing to be the guardian, but just had to go through the court process to get them there. Instead of him just having appointed his wife as the agent on the power of attorney, could have continued seamlessly, right? It just paused the process for a period of time.
Right. So it's always interesting. And when purchasing a co-op, a lot of times you can't purchase in a trust. I think in a condo, I believe that.
So every co-op is different. So sometimes you can't purchase and you can't have a trust as an owner in a co-op. Sometimes it's specifically just irrevocable trust that they won't allow. And sometimes they'll allow it all, but they're going to make your life hell. So it really all depends. I call it like Animal Farm. Like everybody has their own little situation going on.
Right. It's so true. It's so true.
Condos though are like it's a deed. It's a regular property. So you could, unless the homeowners association says something different, which I haven't encountered yet. But
yeah, I don't.
Perfectly fine.
Mm-hmm. I don't see there being a problem with the condo.
Yeah.
And I guess so. The most important thing when, as we discussed before, when a client comes to me, for example, I'm putting actually an apartment on the market in about 2 weeks, and the executor is very organized, and her partner appointed her. They have an apartment that's an HDFC. She has the stock certificate. She has an attorney set up. I mean, is there anything that I need to ask to be prepared so this will go smoothly?
I mean, as long as they have a competent real estate attorney and estate attorney, I think you're good, because they're the ones who are going to be making sure that it was right to call you, the timing was right to call you. Meaning, can the apartment be listed yet? Does the executor have authority to sign a contract yet? And things like that. So assuming that the advice that the executor received is correct, then you should be golden.
Right. Yeah. I like to be golden. I like to know that, like, okay, the right person is signing the contract at the right time. So I know that she has the authority when she's appointed as executor.
I would reach out to the estate attorney if you're concerned, or just if you wanted to be on the same page. I love having a team approach. I like when the estate broker calls me, the real estate attorney. The real estate broker calls me, the real estate attorney calls me. I love when we're all together, that we're all working together. This way, there's no miscommunication. Everybody knows what's up, and there's no room for disagreement because we're all working together.
Yeah, I think it's so important to have collaboration in this process. The estate attorney has already reached out to me.
Perfect.
And I'm already speaking with beneficiaries.
Golden.
Yeah, it's really great when things are smooth and when people want to work in collaboration. I mean, the worst thing is when there's no communication and you don't know what's happening.
Yeah, you have no idea what's fine. Exactly.
Because I think it's important for real estate attorneys, trust and estate attorneys, for everyone to work together. Even when I get a referral from another agent in another market, I always keep them apprised as to what's going on.
Yes.
Because you never know what's going to happen in the future.
And that really applies to everything. It's not just real estate transactions. It's anything going on in this world, right? Where you're having a state attorney, T&E attorney, a real estate attorney, an accountant, a financial advisor, a real estate broker, insurance broker. Everybody needs to be on the same page to work together, because we need to know how the assets are titled, who the beneficiaries are, who the fiduciaries are, the executor, the trustee, the agents. Everybody needs to be on the same page. You don't want to be calling the wrong person as the executor because you didn't know that was not the right call to make, right? You didn't know brother said, I'm not going to be the executor and only sister is, for example. You need to know these things, right? So having everybody on the same page and the same team is really important.
Right. I couldn't agree more about that. Absolutely. And what about real estate investors. I mean, we spoke on, we spoke on co-ops and condos. I mean, have you ever run into any situations? I guess it might be the same process.
Similar yet different, because real estate investors typically have an entity or multiple entities that own the property. And so the entity has some sort of operating agreement, shareholders agreement, or otherwise that will direct how everything will go. So instead of the will, they have that says, so it's not typically it's not going to be a joint with rights of survivorship type situation. I'm not going to be in real estate investment with my friend and then have my husband step into my shoes, because why would my friend want to be in business with my husband, right? So there's typically some sort of buyout or insurance to cover. It's a little bit different.
There's so many intricate details. I mean, we have to think about it. People have businesses, people have children, and people have multiple homes. They might have multiple homes.
Yeah. So somebody who has multiple homes, let's say in different states. So a client has a property in Florida, New York, Massachusetts, California, whatever. In those situations, I definitely want to put them all in one place. So I would create a trust for that person. This way, we don't have to probate in every place where there's a will. It's just all together in the trust, and then it automatically happens. But again, it's so important to think of that, right? To get to that point where everything is pulled together in one place, and how it's going to go if something happens.
Yeah. It's just making me think about, when I meet with a buyer, to ask these relevant questions, if it's possible, to be put in a trust. I mean, somebody that's 30 may not think of this.
That's right. And listen, it may not be right for them at the end, but I always say this when I have my initial consults: the most important takeaway is an education, right? The 30-year-old may not know it's an option. So have a conversation, learn about your options, and then go from there. You may walk away and say, you know what, that's not for me right now. It's not in my wheelhouse. It's too expensive for me right now. It's not affordable for me. Okay. So now you know about it. So in 15 years, when it is in your wheelhouse, or it is more affordable, or it does sound more palatable, you know what that means to put something into a trust. So knowledge is power, as cliche as that sounds, but throughout all of this, everything we're talking about, just having the information, being educated about it. Once you're educated, you can make your decision, but at least make your decision based on something, that's solid, or ask your questions based on some sort of education. And I think education is so important when it comes to this practice area.
No, I couldn't agree more. And probably the earlier you educate, the better.
Absolutely.
Yeah. Well, thank you, Keren. It's been a real pleasure and a real honor to have you on my show.
Thank you.
And, in case some of my guests want to reach out to you, what is the best way to reach out?
Sure. You can give me a call, or you can email me. I guess I'll have my contact information listed below, but I'll tell you anyway. My office number is 516-564-2188. And my email address is Keren, Keren, @BirnbaumLewis.com. And I would welcome the opportunity to talk to any of your guests. Thank you so much for having me, Heather.
Thank you so much. I really appreciate your time and learning all about you and trusts and estates.
Thank you.
Really enlightening. Thank you.
You've been tuning into Heather Sells NYC with your host, Heather M. Cooper. You can find more episodes on all the major platforms, including YouTube, LinkedIn, Apple Podcasts, Spotify, and on our website, heathersellsnyc.com. Thank you for your positive reviews, comments, questions, and for sharing this show with others.